Good morning, everyone. I think it's 11 o'clock. We should probably make a start. Thank you all very much for coming to this policy exchange meeting. I'm afraid, given the excitements of the adjournment or non-adjournment for the party conference, this panel has been assembled at some speed, but we're very lucky to have assembled a stellar panel on this very interesting topic of strengthening the rule of law to drive UK growth. Now, I appreciate that the rule of law is a topical topic at any time, and particularly topical now. But what we would like to do for the purpose of this meeting is to focus on the rule of law in the context of growing UK growth, that is, the broader pictures of law. So we don't want to focus on any one case in particular. Not, of course, that you might have any one case in mind. And we're very lucky, too, that this event has been generously sponsored, both by the City of London Corporation and by the Law Society. And so Policy Exchanges, and I'm sure your thanks to them for that. So our lineup of speakers, as I say, is extremely heavyweight. We have, speaking first, somebody on day release from the Westminster Penitentiary, the Solicitor General, Michael Ellis, QC, and he's going to address us first. As you well know, he's a former minister before being appointed to the Law Office, the position of Solicitor General, and he was formerly Deputy Leader of the House of Commons, so I'm sure he's used to serving a long time sitting on the bench, so he's quite glad to be coming up here, I'm sure. And then we have, speaking next, Katherine McGuinness, the Chair of Policy and Resources Committee of the City of London Corporation, and she's the Deputy Chair of the City UK and the International Regulatory Strategy Group, and she chairs a number of other committees, including the Courts Subcommittee, and is responsible for the Old Bailey and reviving or restoring the City of London Magistrates Court, who have the best-dressed ushers in all of England, as I'm sure you all know. And we also have the President of the Law Society, Mr. Simon Davis, and he obviously commercial litigation partner at Clifford Chance, and comes to tell us about the future from that angle. And finally, but certainly not least, with the overseas perspective, we're very lucky to be joined by the High Commissioner of Australia, the Honourable George Brandis, Queen's Counsel, and I will say no more by way of introduction, than to say thank you all for coming, and invite the Solicitor General to speak to us first.
Well, thank you very much indeed. I'm absolutely delighted to be here. It's a delight to be anywhere outside of Parliament at the moment, but it is a particular delight to be here in Manchester. I am on something called red standby. If I was to receive a text message, which I just have at any moment, then you'll please excuse me if I dematerialise. But I'm not expecting that to happen, and we're not banking on that at all. You'll be pleased to know. So, ladies and gentlemen, what is possible to say about the UK legal services sector that we don't already know? Frankly, we know that it is renowned throughout the world. It is a crucial component of our economy, and that is something that I think is not always recognised. Many people understand that it is a highly respected system, but they don't follow that its value is so great to the economy. Its contribution to our economy is nearly £28 billion a year. It employs almost 329,000 people. It contributes some £4.4 billion to our net exports. Throughout the world, there is no doubt that English law and English courts set a gold standard. I think, frankly, a platinum standard for civil justice. Indeed, most cases, actually, that are litigated in our courts, this is not a well-known fact, or arbitrated in England, they are, frankly, emanating from abroad. Why do people come here to settle their disputes? The first reason is our courts. Our judges They're rightly renowned throughout the world for their independence, their impartiality, their intellect, their competency. And as the Court of Appeal put it in a recent case, one of the interesting features is there's no home ground. You know, people talk about sports and they say, well, you're at an advantage if you're at your home ground. Well, that doesn't apply in our courts in England and Wales. There isn't an advantage for coming from here. It matters not whether the litigants are domestic, foreign, governmental, private, all are treated the same. And that's sadly not the norm around the world in many places. In many places, frankly, it matters where you are from or who you know. That is definitely not the case in English courts, and that gives us tremendous advantage. It's not just the impartiality of our judges which makes England an attractive jurisdiction, it's also the commercial awareness of those judges. Whilst in many countries one becomes a judge, you can actually get a degree and go straight after that to be a judge, straight after law school. In the UK, one would have had to have practiced law, usually for decades, before being appointed. And that means that our judges have directly experienced how the law matters with the commercial world. And therefore, when they are on the bench, they can be trusted to apply the law sensibly to the particular situation at hand. So it's our judges' experience and their acumen that are really valuable. But it isn't just our judges, is it, that are renowned? It's also our law. The common law has developed incrementally, as we know, through hundreds of years, to adapt to new situations. And it's an example of what has been called a spontaneous order. Our doctrine of precedent ensures that like cases are treated alike. This provides much needed certainty, at least it does usually. English contract law is the jewel in the crown of our common law. When one looks at its two key principles, freedom of contract and the objective principle, it's not hard to understand why it is the most popular law to govern contracts worldwide. People from far and wide, two different contracting parties who have nothing to do with England and Wales often write into their contracts that in the event of a dispute, that dispute should be arbitrated in England and Wales. And they do that for a purpose, because it means that our freedom of contract ensures that parties have the flexibility to agree to any terms that they like. The principle of objectivity means that the contract will be interpreted not based on a subjective intention of the parties at the time that they were contracting, but more what a third party might reasonably be expected to understand and perceive that contract to mean. And that ensures that there's a more certain interpretation which allows for third parties to rely on those contracts. So we have tremendous advantages in our system. And on Brexit, for example, we are, of course, it would be remiss of me not to mention it en passant, we're at a key moment in our nation's history. Many people see Brexit as a problem to be solved. I actually disagree. I see it as an opportunity, a positive opportunity to further promote, further strengthen UK law. We are going to regain competence, this is just a fact, over large areas of our laws. This opens up exciting possibilities. For example, the UK used to be a world leader in private international law. You know, Dicey's Conflict of Laws was one of the world's first comprehensive treaties on the subject. And when we leave the EU, the simple fact is that we are going to regain our own independent voice in this matter. We must, therefore, become a world leader again in civil judicial cooperation, something that is essential to London's status as the civil dispute resolution centre of the world. And I really look forward to the UK once again having its own voice in the Hague Private International Law Conference. And of course, we must seek civil judicial cooperation as well with our friends, our European friends, for example, by seeking to join the Lugano Convention. And we must look beyond Europe as well. No doubt you'll recognise that we need to be looking at such things as the Singapore Mediation Convention. So In conclusion, I would just say that the success of the UK legal services sector is due to our commitment to the rule of law and to our common law. We mustn't be complacent, however. There are challenges ahead, and I recognise that. But I am very confident indeed that the rule of law will continue to thrive in this country, and that English law and the English courts will continue to set the global gold standard. Thank you.
Thank you very much. Next, we're going to hear from Katherine McGuinness, the Chair of Policy and Resources Committee at the City of London.
Thank you very much, Simon. And can I just say that the City of London Corporation is really pleased to be hosting this alongside Policy Exchange and the Law Society. I'll also just say that you did slightly oversell me. I'm not responsible for the Old Bailey. I'm responsible for repairing the boilers in the Old Bailey. My committee has an oversight of the maintenance there, but not the running of the court. But when we first agreed to co-host this event on strengthening the rule of law, we really didn't expect it to be quite such a topic of the moment. Yes, one of the UK's great strengths. Yes, something which, when we go around the world telling people of the fundamental reasons why this will remain a strong and important and prosperous a global financial centre, one of the underpinning reasons. But we didn't expect to have had quite the proof that it is as strong in this country as we now have. I'm just going to add 3 thoughts to what we've just said. I will say something very quickly about Brexit, and then I'd like to come on to policies and a little bit about infrastructure. And on Brexit, I just want to underline the importance of delivering a regime for recognising and enforcing judgments from UK jurisdictions in the EU and vice versa post-Brexit, just to make sure that we do have legal continuity and certainty. That is very important to the ongoing primacy of English law, dispute settlement and insolvency, and really vital for those many contracts where English law has been chosen to govern. We do already have an unrivalled system for reciprocal enforcement of judgments in civil matters outside the EU, not only in Commonwealth jurisdictions, but also in many other countries around the world, so it shouldn't be difficult. But it is one of those areas where a no-deal Brexit could call things into question. So there's a lot more one could say on Brexit. I won't. I'd like to look at what policies we might adopt after Brexit to strengthen the rule of law and to strengthen our sector. And I'd like to concentrate actually on 3 issues. Again, there are more we could talk about, but I'd like to talk first of all about visas and the importance of a regime and a system which is open, which enables people to come to the country who we need to serve a global sector. I think one of the reasons that we are so strong is that we do have many global practitioners operating in our global financial centre. So a visa regime which will enable us to bring in people who we need for that to continue is really important. And one where the system works smoothly, not simply the rules, but actually the processes. But of course, it's absolutely essential that we have the right training and skills to make sure that the sector flourishes. And on that, I think looking at pathways so that we can draw in, the greatest, draw in talent into the sector from the greatest range of backgrounds across the UK. And I know that the Law Society and others are looking carefully at that. What can we do to make sure that the sector is bringing in and training UK talent from whatever background? But thirdly, we are facing a time of enormous technological change and technological opportunity. We're seeing the way that people access banks change enormously quickly. We're seeing all sorts of examples of how technology is changing the way we work. And actually the potential for that in law is just as great. Over the last few years, the growth of law tech, not only in the UK, but also globally, has been staggering. The number of companies offering products to assist with contract automation, time recording, and e-billing processes and case management has skyrocketed. And there's more potential for technological support now than ever before. But I speak as a lawyer here. We lawyers are not always the quickest to move on in some of these areas, and there are some very legitimate questions that we need to ask ourselves about the robustness of some of the technologies we're offered. I think that the full capabilities and benefits of this technology have yet to be harnessed. Indeed, we've set up with the MOJ a law tech sounding panel, bringing together tech practitioners, bringing together legal practitioners to talk about some of this and look at where it can be exploited, because it is really important that our world-leading legal sector stays ahead on this front too. We don't want to be overtaken. We don't want to be overtaken by rivals in the Far East, for example. So I said I'd talk about Brexit, I'd talk a little bit about policies, but finally I'd like to mention infrastructure and the importance of having the right infrastructure to support the sector. Yes, we need to invest in our judiciary. It's absolutely a vital pillar of the sector, and one of the reasons we have that edge. And we also need to invest in our courts to make sure that they're up to date. And in the city, we will be playing our own part in that. We are building a new combined courts facility at Fleet Street. We're actually rebuilding our magistrates' courts, which I have to say, having seen the 5th basement, because it goes down a long way, which is full of water, I think it's long overdue. But for many reasons, we are building a new combined courts facility at Fleet Street, which will be specifically designed to tackle fraud and related economic crime, including it'll have a specialism in cybercrime. It'll give the Square Mile another world-class court complex alongside the Old Bailey and very close to the Royal Courts of Justice, absolutely reinforcing London's position as a world-leading centre for legal services, a world-leading centre in the heart of a UK, which of course has many strengths across the country, and I know that Manchester is another great centre for legal services. So this is a sector which is going to continue to be vitally important for UK growth and one of our unique selling points after Brexit. Thank you.
Thank you very much. Thank you very much for that London perspective, and I think we now turn for the Commonwealth perspective, perhaps from the High Commissioner from Australia. Mr. Barrister.
Well, thank you very much indeed, and I know that you want me to give, as it were, an external perspective, but the point I'd make by way of at the threshold is that English lawyers and Australian lawyers largely share a common intellectual space, because notwithstanding the intrusion of extensive bodies of European law into British jurisprudence in the last several decades, it remains the case that the principles of the common law and the equitable jurisdiction, as they are understood by English courts, are the selfsame principles that are administered by Australian courts. And our courts routinely draw upon one another, so that the most frequently cited authorities in Australian courts outside Australian decisions themselves are decisions of the courts of this country, just as the decisions of the High Court of Australia are very frequently relied upon in the development of jurisprudence in England. It's also an intellectual space shared not merely doctrinally, but in terms of personnel. Of the 7 judges of the High Court of Australia at the moment, 3 of them did their postgraduate legal education at English universities, as did the recently appointed President of the New South Wales Court of Appeal, Andrew Bell, the Solicitor General of Australia, Stephen Donoghue, and indeed the Attorney General. So Australian lawyers and English lawyers draw upon the same intellectual wellsprings. For that reason, Australian lawyers are a very familiar sight in the City of London. There are so many of my contemporaries and younger Australian lawyers for whom working in London is a rite of passage. And I do hope that when, after you unshackle yourselves from Brussels and Australia and the United Kingdom execute the free trade agreement to which both countries are committed, then the mutual recognition of professional standards and greater ease of translation of Australian lawyers to England, to Britain, and British lawyers to those great Australian centres of legal practice like Sydney, Melbourne and Brisbane will be easier still, and that will be very nourishing for the careers particularly of young lawyers. Now, I want to endorse what the Solicitor General has said, though, about the reputation of London as a seat of commercial dispute resolution in particular, right across the range of all commercial disputes, but in particular in those areas in which London will always lead the world, like maritime law and insurance law, to name but two. It is a great tribute both to the sophistication of the legal profession in this country and the absolute and stainless integrity of those who administer it, that so much of international commerce depends upon London as the seat of dispute resolution. So I'm advised that in 2017-18, international cases, defined as cases other than those concerning property or events based in the United Kingdom, or where the parties were UK-based relative to the dispute, in other words, cases which did not primarily have a UK component, either in terms of subject matter or litigants, constituted 70% of the matters before the London Commercial Court, and that 59% of litigants in that year before the London Commercial Court were non-UK nationals. That is only possible because of the respect that parties to disputes, or contracting parties who enter into multi-million and sometimes even multi-billion pound transactions, have in choosing English law in the choice of law clause and English courts as the choice of in the choice of forum clause. Equally is that evident in dispute resolution by arbitration. The London commercial arbitration market is the greatest in the world. It's bigger than New York, it's bigger than Singapore, it's bigger than Hong Kong or Sydney or any other potential seat for international commercial arbitration. Australians have been very active as arbitrators in that market. In fact, many of you would know Doug Jones, Professor Doug Jones, who is one of the principal arbitrators practicing in the City of London, and whom, with Lord Goldsmith, was the joint author of the London Centenary Principles, developed by the Chartered Institute of Arbitrators, which sets out the first principles of arbitral practice for the City of London. So, from an Australian perspective, we have equities here, as I said, both intellectually and in terms of personnel. But more broadly, I am very confident that none of the circumstances which have made London the commercial dispute settlement centre of the English-speaking world, and not just, by the way, the English-speaking world, will change after Brexit. The sophistication of doctrine won't change. The skill of the profession won't change. The integrity of the institutions won't change. And therefore, the magnetic attractiveness of London as an international commercial dispute resolution centre will remain constant. Although I would sound one brief note of caution, and I want to echo what Katherine McGuinness has said here, and that is the question when it comes to the enforcement of judgments, of the importance of bedding down within Europe mutual recognition and reciprocal enforcement of judgments. Because it's all very well for the award of an arbitrator to be enforced according to the terms of the award. But that's, as you know, a matter of private agreement between the parties. But there will be a short-term effect on London, certainly on the London Commercial Court, until there is a comprehensive framework for the mutual enforcement and recognition of judgments within the EU. So I hope that is an early priority for those who take an interest in this field. But that caveat aside, I think the international commercial dispute resolution arena of which London is preeminent in the world, will continue to be a field of English preeminence, and so it ought to be. Thank you. Thank you very much.
Thank you very much, High Commissioner. And now the final speaker, the President of the Law Society, Mr. Simon Davis.
Thank you very much, Simon. It's quite common at events like this for the last speaker to say, well, just about everything I was going to say has been spoken by the previous. But this has gone to a ridiculous extreme. As far as I can tell, Michael, the text you may have received was actually not a read text from Parliament. You were sent my speech. Or at least you were sent pages 1 to 3, because the other two speakers got rid of the rest of it. So I'm really winging it now. In relation to why I'm here, so I'm a commercial litigator my whole career, so directly relevant to everything that we've just been hearing about. The role of the Law Society is not just to promote, represent and support solicitors, which is hugely important, but absolutely to uphold the rule of law and fly the flag for UK PLC. So against that background, you've heard from Michael and the others rightly about our strengths, but be in no doubt that they are absolutely under threat. Just talk for a moment about the choice of jurisdiction. The choice of jurisdiction, who is going to resolve disputes, has been a ferociously competitive arena for years. And the reason why is often misunderstood. People often think, sometimes the press say, well, the reason why it's great to have Russian oligarchs coming to the UK to resolve their disputes is like it's a free dispute resolution service and gives lots of money to lawyers. That is not the case. The reason why people want to have their jurisdictions chosen is because if you have confidence in the system of law and jurisdiction of a country, you want to invest in it, you want to do business with the people who are saying English and Welsh law is going to be in their contract, it gives you huge trust in the person sitting opposite to you in the commercial negotiating room. And that is why we have had for years huge competition from New York, from Hong Kong, from Singapore, from Dubai, where common law is being applied. Now, perhaps irony of ironies in the context of Brexit, we are exporting English and Welsh law to the continent because courts there in Brussels and in Paris and in Frankfurt and Amsterdam have said they will be applying English law in their courts and speaking the English language. And why is that? Is because they want that business, and they want in the future businesses, when they're sitting across the table with somebody who says, well, shall we have English law, shall we have New law, shall we go to France, that these all seem pretty equal, and they are not. And we have to be extremely careful to make sure that we are out there explaining why it is that English law and jurisdiction is still a safe choice, to start to give people certainties in a very uncertain world. So we just go therefore with a few examples. The first is that we have to be very careful with our language and with our messaging. Last week, I was in Seoul, Korea, the conference of the IBA, flying the UK PLC and legal profession flag, and people there were pretty stunned, because for years, the message that the UK team has been giving across these kind of conferences is you can rely upon the UK because we respect the rule of law. We have independent judges, and our judges are in no sense elected. We have a decision of the Supreme Court, and the reaction of some is to say, oh, you don't respect the rule of law here? Our judge is not independent, maybe they should be elected. That message landed right in the middle of the IBA, and I think we are missing an opportunity. The decision of the Supreme Court shows that the rule of law is alive and well in this country. We have a government regarded as having overstepped the mark, Supreme Court who overrules it. We have the government in court being told by lawyers that they're liars. We have the press saying identical things. And what happens? Nothing. There are many parts of the world where the result is, and would have been, judges, lawyers, and the press are imprisoned. And some of them are put to death. We've got to get this in context. The rule of law is alive and well in this country. We must be out there saying precisely that. English law. English law under the various treaties, which some of you will be familiar with, the choice of English law and contracts is irrelevant whether or not you're in the EU. And we have to be very, very aware of that as a matter of accurate law. So to the extent that we do hear countries out there saying, well, you can't rely upon English law anymore, you might not be respected, then the answer to that is there is a certainty in the context of Brexit, deal or no deal. English law will continue to be respected, and all the strengths which you've heard about from Michael and others will remain. One of the main factors, actually, the reason why English law is so popular is because common lawyers around the world, the English-speaking nations, are all thoroughly familiar with it. It works. And what you don't have are courts stepping in and saying, we may have a right to terminate a contract, but under the laws of our particular jurisdiction, the state can insist that you exercise those rights in a way which is reasonable and fair. So you have absolute certainty. And if you're choosing English law, well, don't go somewhere else. English our jurisdiction is the right one. We've heard about the strengths of our judges and strengths of our advocates, a fabulous advertisement, actually, for the strength of our barristers. As you may or may not know, the average figures for looking at the Supreme Court until last week was about 30,000 a day. Went up to 4.5 million. And many of them were from overseas, and a better advertisement for the standard of advocacy in this country, I can hardly imagine. Watch the performance of David Pannick and James Eadie in particular. Both of them, both sides. But also a point which is sometimes overlooked, and this isn't me blowing the trumpet of solicitors, but we talk regularly about enforcement of judgments and enforcement of arbitral awards, but more than 90% of cases are resolved by settlement. Who is it who's resolving often ferociously complex disputes about swaps and syndicated loans and treaties? It's solicitors in the City of London and outside who are gluing parties together and sorting problems out, and we are incredibly good at it. Next is that we must make absolutely clear that whatever happens, we are an open jurisdiction to the rest of the world. There are some 200 overseas law firms who are working here. Any lawyers from overseas can practice here. We are extremely open, and that is the message that we will be giving and are giving to Europe. So don't start putting up barriers in your own jurisdiction. We don't have them here. And taking up the point made by the High Commissioner, it's hugely important. We must make sure that bright students from around the world come to our universities to study law and remove any barriers that are there. And let me make that point good. Last year, I was in Kazakhstan, sitting across the table from the Minister of Justice. He brought in his team. I think by the end of it, there were about 17. And he started off by saying, welcome, then he said, and I did an LLM at the London School of Economics. They went through every single one, Bristol, Warwick, Birmingham, LSE, every single one. If we get this wrong in the years to come, it will be McGill, Bocconi, NYU. We must not allow that to happen. We must be absolutely out there saying, students, you are welcome. Please come to our universities, study law here, and go back and put English law in your contracts. And they will, because they're familiar with it and they've studied it. And last, but perhaps not least, we must, whatever happens with Brexit, we must still be an active participant in Europe. There are all kinds of fora and committees. Katherine talked about technology. There's all kinds of pan-European organizations and think tanks which we can still and must still be part of, so that we are not seen as withdrawing from the legal and regulatory scene. we're absolutely part of it, influencing it, being extremely good at it. So, ladies and gentlemen, I conclude with my newly written speech. If we get this right and we show some confidence and get out there, all will be, well, not well, but better. Thank you.
Thank you, Simon, for those words. It reminds me that Kazakhstan is actually a fine example of the spread of the common law, because I think they've fairly recently set up a commercial court, and I think Lord Wolf is the president, and the common law applies. So it's a great example of evangelism of the common law. So now's the time for some questions from the floor. Could I ask you, when you, if you're going to ask a question, if you could state your name and organisation before asking a question, and please don't just focus on one particular case. Sir.
My name is Warwick Clyndeford. I work here at Policy Exchange, and my question really follows on very much from the last contribution. And it's, in recent years, the constitutional law and public law in the United Kingdom has become more active and more contentious. And to what extent, in practice, could any of the controversies surrounding that make decisions about locating commercial law decisions within the UK jurisdictions more difficult? Is it really a bit of an exaggeration to say that rows that we actually have amongst ourselves in the evolution of public law will have an uncomfortable washback to commercial law, or is there a genuine problem?
Perhaps the High Commissioner wants to take that first.
Well, it needn't be so, particularly in London, where the focus of my observations is on commercial disputes, where you have extremely sophisticated and highly specialised commercial law firms and commercial chambers in the four inns of court. I don't think the fact that there may have been a public controversy about a recent decision of the Supreme Court on a constitutional matter should bear upon the reputation of the commercial, the practitioners of commercial law, or the manner in which commercial disputes are resolved either by litigation or by arbitration.
Thank you.
Can I just, sorry, I just because you probably picked up it, and thank goodness for you, Warwick, because actually there was something I forgot to mention, and you just fed me the line, so I do actually have a friend here with relief. I think the point which I overlooked, which is that apart from a very key aspect of the strength of our jurisdiction, which is the independence of our judiciary, is the independence of our lawyers, solicitors, and our barristers. That is not the same in many countries in the world, where solicitors and barristers are sometimes regulated by the state. And that is extremely damaging. And one of the reasons is because when government oversteps the mark, it's the lawyers who step forward and hold them to account by judicial review. And that is, I would say, around the world regarded as really something quite special about this jurisdiction. And to the extent that we are about in a political climate to move into a whole series of debates as to what extent does state have the right to appropriate or otherwise people's assets, I think you're going to find judicial review something really rather more valuable than we thought, and perhaps more attractive than we previously understood. So I don't regard it as a problem at all, Warwick.
Well, Simon alluded to the viewing figures for the Supreme Court. I understand that the viewing figures for the House of Commons have also risen exponentially. Sadly, I can't claim that it's created quite such a favourable impression in the public's mind about the proceedings of Parliament. But look, actually I see these matters to be a very good advertisement for the English legal system. Whether one agrees or disagrees with a particular judgment, as we've all alluded to, the fact is that we have a system that functions extremely well, and that I don't see, to answer the gentleman's question, commercial disputes being negatively affected in any way. On the contrary, I think that all the pointers are towards continuing positivity in that area, and I think that we'll see that market grow, which is not only good reputationally for this country, but actually very good economically for us as well.
I think I'd just say, actually, that anything which appears to undermine the rule of law could be very damaging for our reputation elsewhere. A previous Lord Mayor, so as policy chair, I'm likely to be in this post for 5 years. I work with our Lord Mayor, which is a rotating post. Our previous Lord Mayor last year used to say that there were 17 or 18 factors which made the UK economy great, and the rule of law was the first three. And rule of law, rule of law, rule of law. And I think it is one of the things that gives great confidence. And as you say, Simon, we need to stress the fact that last week actually shows that the rule of law is alive and well in this country. And I just wanted to pick up on your point, Michael, about viewing figures. Apparently the Parliamentary Channel has been having more viewers than MTV. And the Supreme Court more than EastEnders.
Yes.
Interesting fact.
Very good. So,
Not all of it is psychodrama.
My name is Leslie Perrin. I'm a member of the Two Cities Constituency Association, and I also am a client of Simon Davis's firm.
I hope this is going to go well.
I could go on for hours about the overwhelming cost of law, but I won't.
Enough compliments.
I just have a comment about the new building on the Strand to house the fraud trials. Have we not got to do something with the Serious Fraud Office? Because the last time I looked from the interior of a fraud trial, it was taking place at Southwark, and there were only 2 fraud trials going on at the main fraud trials centre in London, and they were both private prosecutions. This is a massive scandal that is accelerating with the ability of the private prosecution bar to deal with these issues. And I do think it's time that the state looked again at its capability in this respect. The only other, I did have a question as well.
this is part 2.
I just wonder if it's too soon for us to cloak the Supreme Court with an impenetrable robe of invincibility, because there are already some extremely respectable, some from Australia even, respectable opinions coming out which suggest that the Supreme Court might have unloaded a few questions that need to be discussed openly, and that perhaps a legislative response is required. And I just don't like to see the profession closing its arms around the Supreme Court quite so quickly. May I have some comments on that?
So, should we take part 1 first, the SFO?
Oh, yeah. Part 1, I mean, look, what is very positive is that we are seeing substantial investment into the criminal justice system under this government. £85 million has just been allocated to the Crown Prosecution Service to assist in prosecutions. We all know of the vast sums being invested into policing to create more police officers. And so we're going to see now this focus on criminal justice as a priority, and others have alluded to this, and that is a positive thing, because I accept the premise that we do need that investment, the premise of your question, and that is reflected. And I think it's highly positive that we have this development, and it's symptomatic, actually, that we have this development in the City of London. It's a recognition of how much needs to be done and how much is being done to support the system of criminal justice, and that includes when it comes to serious fraud. So, of course, there are challenges, substantial challenges in that area. It is complex, it is highly involved, and it is extremely expensive. But we do put that investment in, and we're continuing to put that investment in.
Sorry.
Do you have any comments on part 1? On the?
I do.
I don't.
I do.
Sorry.
But I'll shut up. You know, but But first, the Justice Appeal should know this. Leslie Perrin is one of the long-standing, most creative lawyers of his generation, and it's not to do with being a client. I used to read her writings a long time ago. So Southwark, 3 out of 12 courts are being used. And what's happening out there is because a lack of police investigations leads to a lack of police charging, lack of prosecutions. Therefore, court days are being reduced because the work isn't there. Michael's right, the investment is welcome, but 20,000 police officers, you've got to hire them. That's going to be tough. You've got to train them. Tough. These are years off before you see the kind of impact you want. So don't rain on anyone's parade, but that is still going to be a very serious problem. Supreme Court, just since I'm on a roll, Supreme Court, some people say, well, maybe we should have been able to go to the European Court after that. I do think there's probably room in the future to consider a much broader piece, which is that for generation after generation there has been discussion about should there be some kind of legislation to define what are prerogative powers and to what extent the court should have the right to intervene. I think that is something that should probably be looked at again, but not whether the courts or the representatives of the Supreme Court should in some way be appointed by the state. That's a no-no. Breadth of prerogative powers, Leslie, in the context of intervention, I think, worth having a look at.
I think you have some comments on part 2 as well.
I just wanted to make a comment on the second observation you made, Leslie. So, respect for the rule of law means respecting the authority and the finality of a decision of an ultimate appellate court. That's what it means. It doesn't mean not debating it. In fact, that's what legal academics in particular do, and lawyers themselves, practicing lawyers themselves, of course. The law journals of the world would go out of business if one weren't entitled to debate the accuracy or merits or virtues of a process of reasoning leading to a decision of a court. In fact, was it Lord Denning who once said the Law Quarterly Review is the ultimate court of appeal? So I think we should keep very sharply in our mind the distinction between, on the one hand, accepting the finality and authority of the decision of a court, and on the other hand, the entirely different matter of analysing it and, in an intelligent and respectful way, criticising it.
Yeah, I absolutely agree with George on that. Look, it's perfectly proper to criticise the reasoning behind court judgments. It's not unusual to do that. It is perfectly routine, and there's nothing wrong with doing that. But as has already been said, we don't personalise that, and it is not proper to attack the character of our judges, and I don't see anyone mainstream doing that. I mean, the reality is, it's also perfectly proper to debate where the boundaries are between the executive and the legislature and the judiciary, all three very important branches of government, and where power should lie. So there's absolutely nothing wrong. Our judges are not shrinking violets, and there's nothing wrong with criticising court judgments. We have a robust system, and we want to engage in that and continue to do so. And I see no reason why that isn't going to happen.
And if I may sort of add to that as well, on the question of codifying the prerogative, well, particularly tricky, I might say, in a country with an unwritten constitution.
Yes.
Can I refer you to a book published in Australia in 1932 by H.V. Evatt, then a High Court judge, later a very bad leader of the opposition, who mercifully never became Prime Minister, but was a great legal scholar, called The King and His Dominion Governors. And Evatt, in The King and His Dominion Governors, made the case very powerfully for the codification of the prerogative powers of the Crown.
Yes, that's you.
Thank you. Sam Bidwell for Allen and Deeside Conservative Association. Obviously, going forward after Brexit, a lot of people see the opportunity for renewed, restored and improved political relations with our Commonwealth friends based on a legal and a cultural foundation. Though I think with an Australian on the panel, the less said about the shared love of cricket, the better. But that said, to what extent can business with the Commonwealth in terms of our legal services, to what extent can that make up for a potential disruption to those legal services in terms of our European friends?
Well, let me just start off. I mean, I think, Sam, it's a very good question. I think the main point is not that anyone needs reminding, but the only reason why lawyers exist or indeed thrive is because of client activity, and that's what it's all about. This is all going to be driven by the economics, and to what extent, whatever happens with Brexit, at the moment, for very understandable reasons, because of the uncertainty, I think you are seeing a slowing down of A, capital investment, just domestically, B, inward investment because of the uncertainty. The real question will be afterwards, whatever happens, are we seeing a sufficient, quite fast increase in commercial activity with our Commonwealth brethren, which leads to legal activity? But without the activity, this will not, in any sense, compensate for the falling off of legal work, again caused by the falling off of other trading activities. It's all about the economics and all about the client.
You guys want to make a comment on that?
Well, I think I would just say, yes, we need to be looking at the business opportunities, not just with the Commonwealth, but wherever we can. Opportunities which were there already, but which we really do now need to be building on. And I think that getting back to the question of law, I think the fact that we have given the business world an international language for contracts in the form of the English legal, in the form of English law, is something which is actually quite a selling point when we're looking at what we do with, for example, some of the infrastructure projects around the world. So we have got an export here, which is really important to build on. It's funny that as a country which isn't terribly good at languages per se, we are good at this, having given this language of contracts.
Absolutely. One last question from the floor. Sir at the back.
Thank you. Josh from Vauxhall Conservatives. We're obviously sat here in Manchester, and with apologies to Katherine McGuinness, we've talked a lot about the impact of the legal sector in London and how we attract a large number of clients to London. What could we do to improve international clients focusing on legal firms outside of London, elsewhere in England and Wales?
Good question. Sam, do you want to take a start?
Yes. So we're the Law Society of the National Society, indeed not just national, because we're the Law Society of England and Wales, and we take that responsibility very seriously. I just literally came right now from a round table of law firms from Manchester and Liverpool talking about what we're doing for them in the context of Brexit, how to help. And I think it's such a good and relevant question, because sometimes I think if you were to read the press, particularly in London, you'd imagine that sort of outside London is a sort of wasteland with talent having been sucked into London. And I find it's just completely false. Wherever I go, there are all kinds of law firms around England and Wales who are doing terrific jobs and are sucking in, sorry, it's the wrong word, attracting investment from overseas. So I think the main point is just the words. I think, again, the use of words is very important. I don't myself like to talk about national law society and regional law society or local law society. We are law society. We are societies together. And I think the more that we talk up what's happening in the regions and London, because it's not a zero-sum game. The fact that work goes to one doesn't necessarily mean the others don't thrive. So I'm with you all the way. The main point is just to make sure that we're out there, and don't be in any doubt is that in terms of me travelling, I don't spend my life in Seoul. The previous week I was in Coventry and Portsmouth, and soon I'll be in Liverpool and Manchester, and I travel a great deal, and it's one of the best bits about my job.
And I would like to say I'm really glad you asked that question, because one note I had down is that we have spoken a bit too much about London, and I say that even as a spokesperson for the City of London. There are great law firms around the UK. There are great law firms in Leeds, in Birmingham, in Manchester, in all sorts of other places I could mention. And indeed, many of them have their little outposts in London, but this is not a London-only industry at all.
No, and I would agree absolutely with that. And despite the presence of my friend Katherine on the desk here, I would say that there are places around England and Wales that have an advantage over London. And one could argue, for example, that some overheads might be lower outside of London. Transport issues might be easier. The fact of the matter is that we have a wonderful sector throughout England and Wales, and there's everything to draw people who wish to use English law for dispute resolution to any parts of this country. Yes, it's quite true that, as we all know, that London does draw an awful lot of that, that investment, if you like, but we have been saying throughout, we're open for business. We're also, when I was Transport Minister, I was very conscious of that. When I was Tourism Minister, I said we're also open for leisure, and we'll be after Brexit. We're also open for dispute resolution. And that applies to anywhere. I can recommend Northampton, by the way, as my county court, as my constituency. But no, I think what we've said up here this morning applies throughout England and Wales. Our legal system, the excellence of our legal system, our judges, our court processes applies throughout. And that goes for London, but also outside London too.
Well, thank you very much. Thank you all for coming. It seems to me very enheartening to hear that obviously the legal sector is a vital part of our economy, and we have many potential avenues in the future to grow that sector. But also we have the virtuous circle of spreading the common law and the respect for the rule of law around the world with that tool. So thank you all very much for coming. And thank you very much to our speakers, who've been absolutely excellent. So thank you.
I'm sorry.
Well, good to see you. I will follow up
I think-
on freedom of